Hi, I'm Nicolene Schoeman-Louw.
Hi, I'm Robyn Shepherd.
Hi, I'm Johan Lange, and welcome to our podcast. We are attorneys practicing as such at Schoeman-Louw Inc. in Cape Town, South Africa. Today, we're going to delve into the nuances of options, preferences, and rights of preemption as they're found in various types of contracts. So I'm going to jump straight over to you, Robyn. Could you start us off by giving us an overview of what pactum contrahendi means and its significance in contract law?
Sure. Pactum contrahendi refers to a type of contract in which the parties agree to enter into a further contract in the future. And this means that there is a principal obligation, such as a sale, and a secondary ancillary obligation as well. And our courts have emphasized that these types of agreements must also comply with that in terms of the legislation. For example, a sale of immovable property needs to be a written contract. Now, Nicolene, I wanted to jump to you. If you could perhaps explain to us what an option is and how it operates in the commercial context.
Thank you, Robyn. A option is somewhat different to any other call it right of preemption or offer that may be created in a principal agreement or main agreement. And it is something that is firstly a tangibly enforceable right. And it's usually irrevocable. That's the second point, meaning that the person who gains the option gains an enforceable contract term, which is very much in many ways cast in stone. With that thought, I also want to say that it means that a right or an interest is created, and therefore there could be tax consequences associated to it. And that's why it's so important that when we look at these mechanisms and look at constructing them, that we take some proper legal and tax advice in order to ensure that we understand what we are creating and what the impacts could be, particularly from a tax point of view. An offer in a commercial context often takes the form of a person being entitled to acquire shares in a company, by way of example. In other words, certain conditions need to be met, maybe a certain time frame needs to lapse, and then that option becomes exercisable. So it can be conditional, but it's usually irrevocable. And once exercised, then of course the offeree becomes the holder of those shares. In a real estate context, we often see this manifesting in situations where tenants have options in their contracts to buy the property from the owner when certain conditions are met or a certain time frame is lapsed. And usually either the price is predetermined in both contexts, commercial and real estate, or there's some calculation that we've agreed upon in order to pin the monetary value of this to it from the start. And that's really very useful, but also it's quite restrictive and because it does create an enforceable right from the start. So I think maybe let's delve into the less formal option now, Johan. I'm going to pass the baton to you. What's the difference between option and offer?
So the key difference, as you've already touched on, is irrevocability. Where with an option, the offer is legally bound to keep the offer open for that specified period, which they can negotiate that period. Whereas with a standard offer, you can withdraw the offer before it is accepted. So it's in a sense, it's revocable as long as the other party hasn't accepted the offer. Now, an option clause is obviously where the offerer has undertaken not to withdraw the offer, and that's what makes it irrevocable. Whereas with the standard offer, you haven't agreed that you will keep the offer open. You've merely just made an offer which is open for acceptance, but I, as the offerer, could withdraw it at any point. Now, an option, therefore, is actually very valuable, especially in markets with fluctuating prices such as commodity and real estate, which you've sort of touched on. And the option holder can decide whether to accept that offer in any specified period, which gives them quite a lot of commercial leverage. But, I sort of want to move on and talk about rights of preemption and preferences, because they are also quite useful commercial tools. So Robyn, I wanted to ask if you would be able to explain us how they work and how they differ from options specifically.
Of course. So rights of preemption or preferences, this gives the holder the right of first refusal if the seller decides to sell, unlike an option which can be exercised at any time within the agreed period. A right of preemption only comes into play when the seller decides to sell. So, for example, in a lease agreement, if the landlord decides to sell the property, the first offer must be to the tenant who holds the right of preemption. Nicolene, I know we've already touched on it, but perhaps if you could just explain further how the right of preemption might be used in a real estate context.
Thank you, Robyn. Yeah, I think you've also touched on how it could look from a lease or a tenant and a owner point of view. Of course, there could be a family member or some other person who approaches the landowner and says, if you ever want to sell, please sell to me or contact me first. And the problem is that we don't always record those kinds of requests in writing. And therefore, if it's not linked to an existing lease agreement, for example, it's important to put it in writing, because it doesn't just stem from landlord, tenant, and landlord wanting to sell. I also want to circle back, although you didn't ask me to what it looks like in a commercial context. Now, in private companies, we are not able to offer our shares to the general public, as public companies and listed companies are able to do, meaning that the owners of the company are actually in quote unquote a closed circle. And should any of them wish to exit the company for any reason whatsoever, or are forced to because some event has occurred and the exit is by agreement needing to happen, these rights of preemption become extremely useful and can often be quite limiting to the exiting shareholder or those left behind if they are not constructed correctly. So it's important for us to think about these difficult questions as we enter into these relationships and think, so if we want out, what does that look like? How are we going to determine the value? If we don't have free cash flow, how will we buy out? What does that scenario practically look like? And then, of course, potentially to draw a distinction between someone wanting to exit and there's no bad blood between any of the parties versus someone who's forced to exit because something really untoward has perhaps occurred, and whether or not there should be an adjustment to the exit price. And these are all tools we use quite actively in the commercial context in order to navigate what most certainly is a very difficult scenario, even at the best of times, when we look at these exits having to happen in a commercial context. So with that, then I want to pass the baton over to you once more, Johan. What should we look out for when we put these agreements or clauses together? What are some of the pitfalls?
You've already sort of touched on it. The thing that everybody needs to keep in mind with any contract even, but especially with these types of clauses, is that they are negotiated clauses. They're clauses that you would put into an agreement that the parties need to agree to. And when agreeing to them, it's best to think about the scenarios that may come up. And that's why we usually advise that you consult a legal professional in this regard, because essentially it gives you the opportunity to go through the clauses and maybe look at it from a perspective that you hadn't considered before. And, when it comes to disputes and agreements, having it in writing, both your principal and your secondary agreement is obviously very useful, because you know what the terms are. And you know that both parties had agreed to it because their signatures would be on it. Then, obviously, if disputes arises, we would recommend that you look at dispute resolution clauses. This may include mediation or arbitration. which are alternatives to look at than approaching the courts, which could be quite expensive. Mediation is definitely more cost and time effective, but arbitration can be as well. Arbitration can be difficult sometimes depending on the quantum of, what the dispute is. Then it may not be as cost effective as you would want it to be. And it's also advisable that you make sure that these terms are properly drafted. And that's usually why you would approach a legal professional to do it, because it can be quite beneficial from both parties when you know that your option or your right of preemption or your preferences are drafted in your agreement in the correct way and dealing specifically with that type of contract. Say it was a commercial contract or if it was a property contract, as we know that certain contracts have certain legislative requirements and you need to make sure that you've dealt with those legislative requirements. So just to finish off, we've now had a comprehensive look at options, preferences, and rights of preemptions. And I'd just like to thank, our viewers for tuning in, and if they could please like, share, and comment if you have any further questions, or if you have any suggestions for topics that you would like us to discuss in future. And we hope to see you next time when we will discuss the consequences of employees' failure to report for duty.